Conversations That Matter is a partner program for the Centre for Dialogue at Simon Fraser University. The production of this program is made possible thanks to the support of the following and viewers like you.
Welcome.
Thank you, Stu.
I'm talking to you in your capacity as the past Chief Judge of the Provincial Court of British Columbia, not because of a case there, but because of the outcry after the Jian Ghomeshi verdict, where so many people in the court of public opinion were convinced that he was as guilty as they come, and they've hung him. And yet the courts didn't see it that way. Those same people who were outraged at the outcome say, the system doesn't work for victims of sexual assault cases. We need a different system. Are they right about that?
Those are two separate issues from my perspective.
How so?
I don't see the Jian Ghomeshi case as a poster case for needs and to change the system. Having said that, I don't think survivors are well served by our current system for a number of reasons. But Ghomeshi was anomalous.
Why? What makes him anomalous?
A number of things. It's not the classic he said, she said case, and we have some issues with those, and I'd like to talk about those. But this wasn't even that. This was a case of 3 complainants, all of whom had gone out earlier to the media.
Before going to the police? Before
going to the police. And usually when you have 3, you've got the potential for supportive evidence by one with the others. So what we call similar fact evidence. You can use the evidence of one to bolster the credibility of the other 2 and vice versa. The fact that it started in the media really completely prevented that from occurring. So each of the complainants stood on their own testimony. There is certainly a body of case law that says where a complainant's word is pitted against that of the accused, it's not a question of deciding who's more credible, but we didn't even get to that in this case. This case was anomalous because not only were there inconsistencies in each of the complainant's testimonies, which had to be viewed on their own, but there was late disclosure in the case of at least 2 of them, things that came to light quite late and for reasons that were unclear. And then there was, of course, the devastating cross-examination, the revelation of things that had never been brought to light and that had either been forgotten or I think the judge said, at least in one case, intentionally not revealed by the complainants. I've never seen anything like it. Even with one complainant. I've never seen anything like that.
Well, what were the elements that make you go, oh my gosh, like, where is this coming from, or how did this happen?
Well, the fact that the inconsistencies or the post-offense conduct came to light in cross-examination for the first time, and for whatever reason. So I think that
it's almost Perry Mason-ish.
It is. It's very much like Perry Mason, and as I say, it's very, very rare you would see even one complainant's evidence completely devastated in cross-examination. But even before that, they highlighted inconsistencies in their own evidence, and their rendition of the events were kind of a moving target, even before cross-examination. So for whatever reason, and each of them needs to be viewed separately, although 2 did speak at some length in emails and really seemed to have a motive to bring down Ghomeshi. But even without all of that, it was anomalous in many, many, many ways.
Give me an example of a couple of others.
Well, if you consider the fact that the first complainant talked about being in a car of Ghomeshi's that was very memorable to her for any number of reasons, because it was a yellow Volkswagen, and that led her to believe that he was a gentle person. And the facts showed, the evidence showed that he didn't acquire that car until 7 months after the offense was said to have occurred.
Right, and then the bit about hair extensions, clear memory of it, and then she retracts that. And so her evidence starts to, the weight of the the inconsistencies or facts that are wrong starts to erode her credibility.
Even in direct examination, and then in cross-examination, it comes to light that there was more contact than she had let on. In fact, at least her and I think one of the others denied that they'd had any contact, and then it slowly kind of revealed piecemeal in a way that there was actually significant and pursued by these complainants of Ghomeshi. So this case is not about post-offense conduct on the part of complainants. It's not about that, although a lot of the people who've written about it have said it is. It's not. The judge was very attuned to the fact that complainants may continue to have contact with an offender after the offense. But this was about their complete unwillingness to be forthright with the court. And he called it, I think, deceit in one case. They were not forthcoming in a number of ways. So it's just not something that you see every day.
Just got to get you to hang on for a second while we take a quick commercial break. We'll be right back.
Conversations That Matter is a not-for-profit program made possible thanks to the charitable support of the following and from viewers like you. Please visit conversationsthatmatter.tv and help us to continue to produce this program.
So defense starts to present evidence that destroys the credibility of the complainants here.
Yeah.
Crown Counsel's caught off guard. How and why did Crown Counsel get caught off guard? What was their role in being certain that moving forward, because this was a criminal case, is there not some burden upon them to ensure that the weight of evidence is there and that there aren't these compelling arguments that would undermine that evidence to ensure that the case moves forward to the likelihood of a conviction? Otherwise, why bring it to court?
Yeah, and we can see from the interview of Lucy Dakota in particular that they were alive to the police investigators were alive to the possibility of there being emails and asked her about those, but she was unable to retrieve them. But one couldn't get into her account or something, but it doesn't seem like that was pursued. And in the other cases, whether it was pursued or not, it's unclear. I think at least in the case of Dakota, from what I could see, she'd actually forgotten the extent of the communications. So that, to me, begs the question of whether the Crown should be surprised by that. Is it fair to have them surprised by something their witness might clearly have forgotten about? And it's in the possession of the defense. So it argues in favor, one would say, of a defense disclosure requirement.
Which they're not required to do.
Not in Canada. There's something similar to that in Britain where they're required to give a statement of what their defense is, and also in some cases to lay out the questions that they're going to ask in cross-examination. Had that happened here, the witnesses would not have been taken, nor the Crown, so seriously by surprise, because that was devastating to their testimony. If the inconsistencies were a problem, the revelation in cross-examination of something that's directly at odds with their testimony is devastating. It's irreparable.
But it would have given the accused, the complainant here, or the accuser, the complainant, an opportunity to refresh their memory, to revisit what had happened.
To explain their behavior.
And full disclosure around these kinds of things would actually increase their credibility, to say, you know, it astounds me. Even to say, I had put that out of my mind, there's the evidence now. But when you're caught in that moment in court, how do you get to that point where you're able to, well, because you're still putting the pieces back together, you're probably in shock.
I'm sure everybody was in shock, and I wondered, as I watched, there was a reenactment on W5, and I watched that, and I thought, okay, so if you're Crown seeing that happen in cross-examination, there's nothing to stop you from saying at the end of that, not during it, you can't interrupt cross-examination, but say, I may have some re-examination on this. It's new to us, and so could we have some time with our witness? And there's nothing wrong with that, from my experience. And then maybe put her back on and say, okay, I really had forgotten about that, and here's how I explain it in the context of what happened to me. And the judge made a point about them forgetting things that he didn't think they might have forgotten, or being detailed in some areas and not detailed in others and that sort of thing. But see, to me, those are pretty typical things that happen with complainants in sexual assault cases. What's etched in their memory is going to be the aberrant behavior. And this was aberrant behavior that they were alleging. I'm not surprised they remembered that and actually maybe didn't even remember contacting him after the fact.
So, does this not highlight the fact that we have an adversarial court system where you have the quality of one legal team going up against the quality and resources of another? The environment in which that they are functioning doesn't always serve the interests of the victim as well, especially in this kind of case.
Yeah, I agree that we're not serving the complainants as well as we could be. I'm just not thinking this case is a prime example of that, because the complainants themselves didn't serve themselves well in this case. Setting aside the fact they may have forgotten things, there were clearly things for each of them that they buried or weren't forthright about. So set that aside. The typical case is a sole complainant with a defendant. And it's what we call the he said, she said. And I think we have some problems in that area of the law in terms of obtaining a conviction. We used to have a law of corroboration, which was completely unfair to complainants, and that was abolished in 1983. But the law evolved fairly quickly after that to require that there be supportive evidence of the complainant's version of events separate from her own evidence.
Expand on that a little bit more. Like, give me a bit more detail about why that's relevant.
Well, so there's case law that says you can't choose between versions as a trial judge in a criminal case. So the woman takes the stand and says, I was raped on a date by this man. And the man takes the stand and says, that didn't happen, I wasn't there, or it wasn't me, or whatever he says. So
it's classic he said, she said.
Classic he said, she said. She could be completely and utterly, unassailably credible. That's not sufficient. His denial has to be found to be a lie in order for her to prevail and for him to be convicted. And it has to be found to lie not on the basis of her credibility alone. So really what we're saying is
you can like her, not like him.
You can like her,
and
not
still
like him.
rule in his favor.
That's correct. Yes. You can believe her and
not believe him.
You can believe her and disbelieve him, and then you can convict.
Okay,
right?
but you have to
don't
actually not
disbelieve him. If you don't find beyond a reasonable doubt that his evidence must be disbelieved on the basis of evidence separate from her credibility. Now,
and the key phrase in there is beyond a reasonable doubt.
Beyond a reasonable doubt, yeah.
Because that's the basis of our criminal legal system.
Yes. So I used to despair when I saw a case coming in like that, where it was a complainant based solely on her own evidence. And sometimes it was obvious to me that a little bit more investigation would have gotten something corroborative, we don't use that word, something that would be supportive of her testimony, or that would poke holes in his. And it hadn't been pursued, and basically I was left to weigh two versions, a denial. And flat denials are very hard to poke holes in. No, it didn't, you know. But I would despair. I would kind of look at the crowd and say, my hands are tied. The law requires me not to prefer her version of the events.
This is our second break. We'll be back in a moment.
Conversations That Matter is a not-for-profit program made possible thanks to the charitable support of the following and from viewers like you. Please visit conversationsthatmatter.tv and help us to continue to produce this program.
Knowing that, I want to go back to the responsibility of Crown and the police. Why do Crown push forward if they cannot support that with the evidence? And not just in the Ghomeshi case, but in so many other cases, you wind up with a situation where the accused goes free.
I think that there's, sometimes it's just that they're not aware that's required. Sometimes it's because
Crown wouldn't be aware that that's required?
But I think some of the time it's because if the complainant is credible and has a cohesive set of facts, then probably the defendant will have to take the stand. They're hopeful that they'll be able to shoot holes in his testimony and prove him to be a liar in some way or another that will affect his credibility on the whole and permit the judge to reject his evidence and accept that of the complainant. Those Perry Mason moments, in my experience, they're not frequent, but there are times. I had a case shortly before I left the bench where I did on the basis only of the defendant's evidence, find that he wasn't credible. His denial was not credible. And therefore I was then able to go back and look at the complainant's testimony, which you still have to do. If you reject the evidence of the defendant, you still have to look at the Crown evidence as a whole and see, is there proof beyond a reasonable doubt? But that was a he said, she said, where the Crown had successfully, poked holes in his testimony, or cross-examined to a point where I could see he wasn't credible.
So if you have physical or corroborating evidence, then the testimony of the accuser takes on greater credibility and starts to create an environment where there's beyond reasonable doubt.
That's correct.
So many women post the Ghomeshi verdict said, oh my gosh, the system isn't working for women.
Yeah.
We need a new system.
Yeah.
Well, okay. Is that possible? Do we need a new system? If we do, how on earth do we make it happen?
Yeah. I just want to say for a sec about, the part of the reaction there was the, hashtag I believe. And so it's hard to disagree with that sentiment because so many complainants are telling the truth. Such a huge preponderance. And the point at which they need to be believed is when they come in with the complaint and when it's investigated and when it's presented by the Crown. That all needs to be accepted, and they need to be facilitated in presenting their evidence in the best way possible. The point where that doesn't function is in court. There's no presumption of guilt. There's no presumption of believability on the part of the complainant. Usually she, but the complainant and the defendant come to the court with the same degree of credit. That's the requirement of the criminal law. So,
which isn't the case in the court of public opinion.
Definitely not. Yeah. Definitely not.
So they come in with the same level of credibility, and the case that's presented in court has to be compelling one way or the other.
Yes, exactly, and compelling beyond a reasonable doubt in favor of the complainant's version to get a conviction. But
if in a criminal case.
In a criminal case. So
but if you
do we need another
it,
system?
Yeah.
It depends on the result that you or the public or the complainant are aiming for. So if you want to bring this to light and exact some kind of punishment that isn't criminal sanctions, there is the whole system of civil law of suing. The problem with that is it's prohibitively expensive for most people to pursue that. But if you're able to do it, or if we facilitated that for complainants, then you've got a balance of probabilities, and it's completely open to the judge to accept one version over another that's slightly less credible.
Because it's now no longer a criminal matter.
Yes. It's a 50+1 kind of proposition on a balance of probabilities.
But then it is the accuser who has to then decide what is the best.
The accuser, the complainant, yes. The survivor has to. No, but she doesn't. But if she were to initiate proceedings, yes, that would be her decision. But, often with a criminal case, it's not the survivor's decision either. If the Crown think it's a serious enough case, they'll bring it.
They're going to take it.
And they'll subpoena her.
Before criminal court.
Yeah.
Huh. So, are there mechanisms in place for us beyond that to create an environment where judge and jury, which we're seeing less of, but where they have the ability to reach beyond the evidence that's been presented in court, or create an environment that allows them to determine the validity of statements that have been made?
I think we can do that. We can't change the criminal system. There are constitutional issues with that. There's case law. So even if we create a domestic violence court as a criminal court, you've got the overlay of the law.
Because we do have family law court.
We do in some provinces. We've had domestic violence courts here as well. Sort of a combination of family and violence courts.
And that's mostly to protect children.
Well, generally, yes. It was also, I think, intended to be a more receptive environment for complainants in the past. It didn't turn out to work particularly well because you can't change the criminal law. It's going to be there, and you're still going to be struggling with the same issues. So, I mean, we could probably look at, and it would be within a constitutional possibility to have provinces look at a system of civil justice for survivors that involved a balance of probabilities, that had some assistance for them in navigating, that was the word used in Ghomeshi, in navigating the system, in maybe in assisting to investigate and find supportive evidence if need be, and then that sort of thing. We could set that up. It's a matter perhaps of funding, but it's not something that is outside the constitutional realm of possibility, because civil courts are within the civil law is within the purview of the provinces.
Final break. We'll be back in 2 minutes.
Conversations That Matter is a not-for-profit program made possible thanks to the charitable support of the following and from viewers like you. Please visit conversationsthatmatter.tv and help us to continue to produce this program.
Is it not fair to I don't know, agree with the statement? I've read it in a number of different publications and so on, that our court system favors the rich because it's the quality of the defense team, or if you're going into a civil case, the richer team wins.
The deeper pockets, yes.
Is that a fair system? And if we take a look at what happened in the Ghomeshi case, you could say that it played itself out that way. And I would argue that probably in so many sexual assault cases, the man is more in the position of power, has greater financial resources, and therefore the system kind of weights in their favor.
Yeah.
And does that not then bring to light some of the challenges that are inherent in an adversarial court system?
Yes. Well, criminal less so. In my experience, criminal is less driven by the deep pockets of one party or the other. Certainly, Jian Ghomeshi was able to afford high caliber representation.
Who did her job exquisitely well.
Extremely well, but even a junior defense counsel, given essentially the gift of those communications that the complainants had forgotten, would have been able to basically destroy the witnesses in cross-examination. It was anomalous. And certainly, yeah, if people pay for high caliber lawyers and expect that will make a difference, but there's a duty on the part of the court. And my experience as a judge was, it's a solemn inquiry into the truth, and so you're not going to let one party skew it to that extent. It's your duty to ensure that it's a fair trial. And if one party is not represented, and the complainant, of course, isn't, but the Crown is there to present the Crown case. But in a civil case, if one party is not represented, the judge has the job of being their representation.
Okay, and does that move us a little bit closer towards the French system, which is some call truth-seeking, where the judge is able to then reach beyond the courtroom?
Well, we still operate on the principle that what happens in the courtroom is all that happens.
And that's what you're allowed to judge on.
That is all that you can judge on. Yeah. Only what happens in the courtroom. So there's no investigative role on the part of judges, and very little on the part of prosecutors.
So, in your opinion, our system works?
I've said Ghomeshi is not an example of the system not working. I also said in the same post.
I know you are. I'm not lumping it in there. I'm saying, is our system working? And it's what we have to have faith in that system.
Our system of justice in Canada is one that we may be very proud of. It's one of the best systems in the world.
Thank you for coming in and giving us this explanation.
My
it's
pleasure.
A complicated topic.
Yes, it is.